And so I'd like to formally welcome and introduce Inês to this evening's session. Inês Bragança Gaspar is a Portuguese lawyer specializing in Web3, blockchain, crypto, and she has experience in advising projects, startups, and companies of different sizes on several legal, strategic, and regulatory topics in the field. She is the co-coordinator of a postgraduate course on digital law and a guest lecturer of classes in several blockchain topics in different Portuguese universities, as well as being a co-founder and chief legal officer of a DeFi startup. Inês is also currently researching the use of decentralized justice for solving disputes related to the tokenization of real-world assets as a Kleros fellow, and she will talk about that in greater detail during the session. And so without any further ado, I want to pass the floor to Inês to begin the session. And I believe that she will start by taking us through some of the basic concepts of blockchain technology as a basis for the tokenization of assets. Inês, please.
Thank you, Sean. Hello, everyone, and thank you, ArbTech, for having me. I am really interested in everything blockchain related, especially DeFi and tokenization of real-world assets and decentralized justice. And in this presentation, I will present you a bit of my ongoing research around both of these topics, and I hope that you all enjoy it. So, to understand what tokenization is, we will need to first understand what are some of the basic concepts around it. So first off, what is blockchain? In very simple terms, a blockchain is a distributed database that maintains a continuously growing list of ordered records, the blocks that you see on this image that are linked through cryptography. And each one of these blocks contains a cryptographic hash of the previous block, so you can always see the chain. That's why it's called blockchain. And blockchain is the underlying technology of cryptocurrencies. I'm sure all of you have already heard about Bitcoin. You might have heard about some of the other cryptos that are represented in the logos of the left-hand side. We have Ethereum, Dogecoin, XRP, Litecoin. But what exactly is a cryptocurrency? So if you search the internet, multiple definitions will appear. It might even be a little confusing to understand the distinction between digital, virtual currency, crypto assets, token, cryptocurrency, and all of these other existing terms. For example, I recently gave a class just on the different types of tokens that exist, so I could spend a good hour just speaking about this topic. But very, very briefly, and since there are probably lots of lawyers in the audience, I will tell you how MiCA, which is the Market in Crypto Assets Regulation, how it defines a crypto asset. So it says that it is a digital representation of value or rights which may be transferred and stored electronically using distributed ledger technology or similar. And please note that a blockchain is a distributed ledger technology or DLT, but not all DLTs are blockchains. And there are many types of crypto assets, but I would say the main division can be done between cryptocurrencies, which are also called payment tokens, and tokens. So cryptocurrencies like Bitcoin, for example, are the digital assets that are native to a given blockchain network. That's why you have Bitcoin, the crypto, and Bitcoin, the blockchain itself. And they can be traded, they can be used as a medium of exchange and as a store of value. So I would say that most cryptocurrencies aim to be an alternative to cash. And tokens that you can see the logos, some of the logos on the right-hand side of this slide are digital assets that are built and used on top of a blockchain network, and they serve a specific function. So there are many types of tokens. You have utility tokens if they give access to a certain service security, if they represent a stock, a bond, or another traditional security. A governance token in case it allows its holders to vote on decisions of a certain decentralized organization. Then you have NFTs, which I'm sure all of you have also already heard and that are very important to understand the next slides. NFTs are unique tokens that cannot be interchangeable. And I mean, here in these logos, you have BAT, you have FIL, you have USDT, which is a stable coin, etc. So now we move on to what is tokenization of assets. So it is a process of issuing digital tokens that represent physical assets on a blockchain. And obviously, as this technology keeps evolving, we have new ways to manage and to monetize valuable physical assets, which in this field we normally call real world assets, so RWAs. So now I will continue referring to with this term in the rest of this presentation. So tokenization is able to bridge these assets with their digital counterparts. So it eliminates intermediaries. It can provide liquidity to otherwise illiquid and non-fractional markets. I'll also explain this a bit better in a few slides. And there have been several initiatives by international organizations, by companies, by banks to tokenize different assets. And we'll probably see a lot more applications in the near future. You might have also heard the term DeFi. So DeFi is short for decentralized finance, which is any type of finance that uses blockchain as its underlying technology. We have some DeFi companies that are working on this space of tokenization of RWAs. We have, for example, MakerDAO, Centrifuge Protocol. You might have probably already heard about them, and many others, but I would say these are the two main ones. So what assets can be tokenized? First, we need to understand the difference between tangible assets and intangible assets. So tangible assets hold a specific monetary value and they have a physical form. Some examples are real estate, commodities like gold, oil, art in its many forms, or other assets like invoices, or even like whiskey, let's say. Then we have intangible assets that are assets that don't have a physical form. So you could think of voting rights, ownership rights, patents, IP licenses, and so on. And another important distinction related to NFTs is the difference between fungible and non-fungible assets. So fungible assets are tokens that have equivalent value to each other, and non-fungible have a unique design and are not interchangeable. And in this presentation, I will focus more on tangible assets and on tokens backed by them, because that's what I've generally been researching about. And how exactly does tokenization of an asset work? So first, we will need a physical asset to tokenize. It needs to be audited to verify its value and its unique characteristics. Secondly, we must choose a type of token that suits the asset itself and its business model. I'd say that normally NFTs are the most effective and efficient solution for tokenizing physical objects, but we have other examples. Then before issuing the token, it is extremely important, and this is where lawyers like me come up. It's very important to understand the existing legislation and regulations, not only on asset ownership, so I'd say more traditional legal fields, but also on token issuance and distribution. And not only on the different countries where the token will be launched, but also where investors will be targeted, because some jurisdictions don't allow for marketing of crypto or of tokens. Projects need to be very careful in choosing the jurisdiction where they will launch their business. Then we must choose a tokenization platform, or obviously, if we have the coding skills, we can code this ourselves. But tokenization platforms are businesses that offer tokenization as a service, and they take care of all the technical coding requirements for tokenization, as well as issuing and distributing the tokens. And they can also sometimes facilitate trading between investors. So they can even have some type of secondary market on their platforms. And since we are using blockchain technology to tokenize these assets, smart contracts play a big role. And what are smart contracts? They are programs that are stored on a blockchain, and they run when predetermined conditions are met. So if X, then Y. And a smart contract normally encodes the most important characteristics of the token, such as, for example, the circulating supply of the token. So how many tokens are launched in total. Also, if a smart contract has an oracle, which can get information from the real world, it can also be programmed to act in the case that something happens to the assets. Then the asset holder should surrender the physical assets to a verified third party to ensure its safety and also its authenticity, although it has already been previously audited or should have been. In some cases, like with real estate, I would say storage is not exactly possible. So a vault might instead hold some key documents that are related to the assets. And finally, after all of these steps are concluded, the tokens can be issued and distributed to the investors. This is not a definitive checklist. There might be some other intermediary steps, or some of these steps might not even be necessary depending on the case. I would say that tokenization has several benefits when compared to traditional ways of investing. We have, first off, increased liquidity, because tokenization enables investors to perform actions using only a small portion of the asset. This makes investing more accessible to a wider range of people, so it effectively reduces barriers to investment. Think, for example, that you can invest in a tokenized day spa in Thailand, and you can get some of its revenue. You can invest in a token of a co-working space and get some of its benefits and perks. And you're also financing these businesses in an alternative financing way. Then we have automation. So the smart contracts, if they are coded for that, they can allow for example, trading, compliance, document verification, dividend payments to be automatically executed if certain predetermined conditions are met. This removes the need for some traditional intermediaries that would do these tasks. We have increased transparency. So obviously, by default, blockchain implies that everything is getting registered on the list of blocks that I showed you on the first slide. Also, asset tokenization allows users to view the entire history of activity that was performed over a certain asset, and also the associated chain of ownership. And for example, some commercial registry offices, for example, I think in Brazil, they already use blockchain technology to register real estate. So I believe that more governments are going to continue using blockchain for registry purposes. Then we have immutability. All data stored on the blockchain is theoretical, immutable. So data cannot be manipulated very easily. Then we have increased accessibility. So imagine an investor that cannot afford high value assets. Obviously, fractional ownership allows for these investors to access some assets that they would not be able to do otherwise. And obviously, tokens can be exchanged globally and virtually at any time. So this also increases accessibility. We have monetization. If the RWA generates income, the profit can be split amongst the token holders based on how many tokens they own. And finally, we have authenticity and security. So NFTs can act as a digital record of authenticity, and they might even themselves have a digital certificate of authenticity in them. So think about a famous painting or a signed music album. They derive their higher value from these authentic and unique characteristics that should be verified through the NFT. And then we have security. Obviously, blockchain is as a distributed registry. Each computer on the network has a copy of the database. It's decentralized. There's no single point of failure because there's no centralized entity controlling it. These are two of the main characteristics of a blockchain. So it's obviously a lot more secure than, say, a Google Drive or some centralized platform where you can record data. But we don't have only benefits and challenges. We also have, benefits and advantages. We also have risks and some challenges, namely technical challenges besides the general concerns that any blockchain project should have regarding security, making sure that the smart contracts are well coded, as well as having constant auditing to avoid exploits, hacks, 51% attacks. I'd say that tokenization projects also have their own unique technical challenges, such as ensuring that there is consistency between the off-chain RWA and its on-chain counterpart, so the digital token that represents it. I would say that legal and regulatory uncertainty is definitely one of the biggest challenges for tokenization projects. They're normally managed in a decentralized manner. They have global teams working remotely. The tokens are being targeted to investors worldwide. So it's very important to study beforehand and to use lawyers to advise on these projects. And then we have dispute resolution. Like with any other business transaction between two parties, there is potential for disputes to arise out of these contracts and negotiations. And I'll further expand on this point in the second part of this presentation. Then we have governance issues. This is not unique to tokenization projects, but I would say that most of the times when crypto projects fail, it's mainly due to governance, lack of experience, and accountability of the team behind it. So this can also lead to the appearance of legal disputes. Then we have standardization, or rather the lack of it. Token standards facilitate trade, they protect investors, but it takes time to create these standards, especially in such a still emerging technology like blockchain. Some organizations like Two Tokens Foundation and the International Token Standardization Association are trying to raise awareness about these standards. They're trying to organize discussions between key players and study how to reduce barriers for the adoption of tokenization. And this will take many years to come to fully come into fruition, and it will require all these efforts and cooperation between different actors, and also lawyers will be very needed in this discussion. For me, one of the most interesting topics on tokenization is how it is used to finance companies. I will not take a long time on this slide, but there is currently a huge global trade finance gap between the amount of credit that is available in the market and the amount that companies need for financing, especially micro, small, and medium companies, and especially those that are located in countries that have weaker economies. So some DeFi companies, like I've mentioned, like Centrifuge, MakerDAO, and DFactor, which is another company that tokenizes invoices. through this tokenization of physical assets that these companies already own, they can get access to alternative financing methods that are powered by blockchain technology. And this makes them less dependent on banks that they cannot always access, also from informal lenders, which is a big worry in some countries, and it can lead to the exploitation of people, families, and even whole communities. So what are some of the possible legal disputes that can appear? And now I'm starting to enter the second part of this presentation. I think I'm right on time. We have ownership issues. So owning the token does not necessarily mean that you own the underlying asset that the token represents. For example, if you own a piece like a token of a painting, it does not mean that you own the painting. If some famous painting is tokenized, it doesn't mean that you're the owner of that. And some jurisdictions have already addressed the disconnect between physical objects and their digital twins, like, for example, the Liechtenstein Token Act. We have IP rights issues. So an NFT can represent an asset that is subject to protection by IP rights. For example, you can buy an NFT. You might not be able to print it or display it in an art gallery or commercialize it. It depends on what is coded in a smart contract. And I think if you are interested in this, you can check the Meta Birkin case, which is a very recent court case. And also, I think there was a case also about Bored Apes NFTs. So that is very interesting. Then we have verification off-chain of the RWA and a possible mismatch of its digital representation. Think, for example, a fire that destroys a house, a tokenized energy grid that gets interrupted. So if the token is not coded to be dynamic in price or tied to the fluctuation of the value of the real-world asset, we might have a big problem here. Some examples of real-world disputes are, for example, two cases where the US Security and Exchanges Commission exposed two initial coin offerings, so ICOs, that the tokens were reportedly backed, one of them by real estate, the other one by diamonds. And this was found not to be true. So the companies had not bought the physical assets, so the tokens were not backed by anything, and they were being targeted to investors as such. And then we have smart contract bugs. For example, in 2022, we had millions worth of NFTs that were stolen in an NFT marketplace. We have, for example, a UK High Court case, if you want to check it out, of Lavinia Osborne versus unknown persons and OpenSea, where allegedly someone stole two NFTs out of her digital wallet. And the court ruled that NFTs are considered property. And so victims of NFT theft can have their stolen assets frozen through court injunctions. And then we have jurisdictional issues. So because of the globalized nature of the issuance and even the negotiation of tokens, we can have jurisdiction issues leading to uncertainty which court will be competent to solve these disputes. So what exactly is decentralized justice? For me, it's a very broad term. It can encompass several blockchain solutions to solve disputes or to automate some part of the decision-making process, or nominating jurors, or using game theory on decentralized arbitration. I found a definition of decentralized justice in a research paper from 2018. I think this was the earliest definition that I could find. And it says that decentralized justice is a form of digital courts that is supported by blockchain technology, whose purpose is the settlement of disputes by crowdsourcing jurors under economic incentives to provide fair rulings. So we have two main things here, two main characteristics. We have the jurors and the economic incentives, and those obviously using blockchain. Also, according to Federico Ast, which is the founder of Claros, which we will talk around in a bit, a decentralized dispute resolution system needs to comply with 3 conditions. So first one, to be built as a DAO, which some of you might have already heard the term, which is a decentralized autonomous organization. It needs to be based on a mechanism design that uses crypto economic incentives, and it has to generate a perception of fairness. So just like miners are rewarded with small fractions of Bitcoin for using their computer power, so the electricity in their house, their hardware, their time to mine Bitcoin per the proof of work consensus mechanism, jurors in decentralized justice also lend their time and their skills to the network in order to solve disputes, and so they are rewarded with some type of crypto economic incentive. So what are the main differences to traditional justice? So in the global world, where parties can be on opposite sides of the planet, a decentralized justice platform can be hugely beneficial to solve disputes not only in a faster, but also in a more effective and efficient way, and also with a reduced cost. As we all know, arbitration procedures can be very expensive. And as everything gets registered on the blockchain, you can have the key moments of the procedure, you can have court transcripts, submitted evidence, and arbitral awards can be all registered and available to the at all times to the parties. And obviously, this technology can also be used to traditional courts as a tool to do all of this. But that is not what we are talking about today. Some of the disadvantages are that the centralized courts are not ideal to every single disputes. So we have, extremely complex disputes. Disputes have lots of evidence or certain topics that are not covered by a decentralized court service that they offer. This might not be suitable to be presented in these platforms. Also, another very important point is the lack of recognition and subsequent enforcement of an arbitral decision by a decentralized court. Again, I could present a conference of several hours just on this specific topic. If you are interested in it, I invite you to read some entries on Clarus's blog, and especially the entries with the research of previous Clarus fellows. And the titles are How to Enforce Blockchain Dispute Resolution in Court, the Clarus Case in Mexico, and also Is Clarus Legally Valid as Arbitration? So if you are interested, I would recommend you to read these 2 blog entries. Then obviously we have security risks. These platforms can be exploited. Most of these projects are open source, meaning that the code is available for everyone, which is good for transparency and auditing, but it can also be used by hackers to exploit these platforms. And just like most blockchain applications nowadays, I would say that using a decentralized justice platform and becoming a juror might not be very easy for everyone to do. So the user interface, the UI or the UX, the user experience is normally targeted to crypto natives and tax savvy people. So someone that does not know how to create a digital wallet, for example, like MetaMask, they probably cannot access these types of platforms very easily. And I would say these are the main disadvantages that can be presented. And there are already many different projects that are pursuing one form or another of decentralized justice. You can see some of the examples on this slide. The most famous and widely used one is arguably Claros, and I'm not saying this just because I'm a research fellow for them. It's the truth, statistically wise. Here I have to make an obligatory disclaimer. I don't work. For Claros, I don't represent them. So all I will present here are my own views. They do not represent Claros' views. And this visual graphic is just for you to understand how does Claros work. And it was taken from Claros' white paper, which I also advise you to read if you are interested in this topic. And here you can see a dispute between Alice and Bob. So imagine that Alice was contracted by Bob to provide services as a freelancer to, for example, build a website from scratch. I don't know. And Bob argues that Alice did not deliver on the agreed terms, and Alice argues that Bob is not paying her for the services that were already provided. I just made this up. And since they want a fast and cheap resolution of their dispute, they bring the dispute to Claros. They choose the e-commerce court because Claros has many types of subcourts. Depending on the topic of the dispute, you have, for example, insurance court, token listing court, content moderation court, and then the jurors are selected, and the jurors have to stake their tokens, which in this case are called PNK, which are Claros' tokens. They stake in this specific subcourt, so in this case, the e-commerce court. And then they are randomly selected. You can see here that these 3 jurors were selected. 2 of them voted for Alice and 1 of them voted for Bob. If the jurors' vote is in accordance with the majority, they receive the tokens that were deposited in the smart contract as a monetary incentive. If they if they are the minority, they lose the stake tokens. And then there's also the possibility of appealing this decision inside this own platform. And I mean, obviously, this is a very simple explanation, but it just kind of shows what is the role of jurors. And you can see that they kind of act as arbitrators in this case, although they are not chosen by the parties. They are randomly chosen. So finally, and I'm reaching the end of my presentation, I believe that a platform like Claros can be integrated into tokenization of real-world assets platforms. I'm just researching for financing purposes, so it's an extremely specific use case. But I believe it can be used for 3 main use cases, amongst others that I'm still researching, and I appreciate if any of you have more ideas that we can discuss. So the first case will be for due diligence purposes. So, for example, you can submit a video and key documentation of the RWA onto Claros platform in order for the jurors to vote on the validity of the asset, and if the information on-chain is correct and up to date with the off-chain information. I believe that Claros can also be used as a KYB, so know your business tool, to onboard asset originators. These are entities that aggregate RWAs. And the onboarding process normally consists, I mean, it depends on the platform, obviously, but it normally consists of submitting legal documents, let's say articles of association, the list of shareholders, copies of identification documents, as well as also performing all types of compliance checks, as well as risk and credit assessments. I believe that Claros can also be used to onboard liquidity providers. So they are the so-called investors. In this case, they stake tokens, stablecoins, crypto in liquidity pools. And the role of these tokenization platforms is normally to tokenize the asset from the asset originator into NFTs. Then they send them to the liquidity pool, which is a kind of a crowdsourced pool or pot of digital assets that are locked into a smart contract. And then the liquidity provider gets some type of return for having staked and for providing liquidity for this liquidity pool. Another use case that I see for Claros is, for example, acting as a custodian for the RWAs. So a smart contract is able to, again, if it's coded for that, and if it complies with the existing legislation on a given jurisdiction, it can legally bind a fiduciary to act according to whatever directions are established in the smart contract for the tokenized assets, and perform any necessary real-world actions if they are needed. And then obviously Claros can be, and this is the most obvious use case, it can be integrated as a dispute resolution platform, let's say between the asset providers and the tokenization platform, between investors and the platform, deciding on disputes related to technical issues like token listing, the platform being down, yields or returns not being distributed to the liquidity providers, etc. I mean, here we have a lot of different cases, and what we need to think is, are these cases going to traditional courts? I mean, does a judge, does a lawyer, does a prosecutor know what a token is? Do they know what blockchain is? Do they know how it works? Or will these disputes be directly sent to platforms like Claros that are already integrated into these tokenization businesses? Obviously, only time will tell. I'm still researching about this. And in case you want to help with my research, I conducted a questionnaire on this topic. I already got around 65 answers. I'm kind of trying to reach 100 until the end of next month, which is when the Claros Fellowship ends. So feel free to scan this QR code, and it leads you, it's not a virus, okay? It leads you to an anonymous Google Forms. And feel free to ask me any questions, give me any commentaries. If any of you are also working on this area, feel free to intervene now.
Great, Inês. Thank you very much for a very detailed presentation. Perhaps while people are writing their questions in the chat box, could I take you back to the advantages and benefits slide, because I just want to drill down into a couple of interesting elements that you kind of dealt with in passing. So I think the liquidity point is very, very interesting. And when you mentioned liquidity pools, I think what people maybe who don't have a financial background is that they may not understand is the fact that, you know, having a market for something, say it's a real world asset that's been tokenized, liquidity is still something that's very important to affect the price, the change in price over time for that asset. So say if we were to, I don't know, even take NFT art, if there is no liquidity in that market and two pieces of that art are sold for one for half the price of the other, and that is the only two transactions, then if you were to average out the price, the value of the art, it's probably the difference between those two assets. So I think this is a very important topic, and I think it's something that maybe especially lawyers should understand as part of their practice. But
yeah,
I think
for sure. And one very important thing for those of you that would like to practice what I call blockchain law, which obviously doesn't really exist, and also the thing that really draws me into blockchain and this whole ecosystem is the fact that we need to know a little bit about finance, about politics, about game theory, about programming, legal, compliance, regulatory. So working with blockchain projects really forces us lawyers to be specialists and also generalists at the same time, which is very interesting. And I mean, I don't know if all the people that are here are lawyers or not, and I apologize if no one here is a lawyer. But yes, that's definitely a very important point. And even to work with these types of clients, we really need to dive very deep into banking and finance the traditional way. For example, factoring, which is something very specific, and some tokenization and blockchain projects are doing factoring on blockchain. So obviously, you first need to understand what factoring is and how it is done by a traditional bank before understanding how blockchain can be used to do that in an alternative way, let's say.
Absolutely. And then I suppose the other thing I wanted to ask you about in the next slide with challenges, and this is from personal experience working with a blockchain company way back 6 years ago at this point nearly, is just, I suppose, from the technical point of view, when you're dealing with real world assets and you're creating a digital twin on the blockchain, or a digital twin even in a centralized computer database, you have always the problem of how are you physically going to tie that digital representation to the physical object. And so it's all well and good when there's real estate and it's not going to move, as you said, and it doesn't need to, you know,
yes, but if it's
you don't need to worry about it.
Yeah, or a
Yes.
bottle of whiskey, it's obviously a lot more difficult, and that's why I believe using a solution like Claire's or any other to act as a vault or as a custodian is also very important. We are seeing more and more solutions like these ones that are just focused on this appearing on the market, because there's definitely a huge need.
Yeah, for sure. And I think that's something that we will probably see quite a few disputes about and I think it's a great point where you said about obviously the real world asset changing, because the real world, you know, brings up things that we may not conceive, and that the blockchain may not update often enough, but also about, you know, counterfeit items, you know, counterfeit art, for example, or any kind of commodity will say that, you know, you were saying that you have X amount of it, but you may not have X amount of it, or the quality of that amount is not, you know, exactly what you say it is. So I think we will see those kind of old school, I suppose, fraud cases, misrepresentation cases, where, you know, things are being sold that aren't actually, you know, what they claim to be. And I think this is, again, comes back to your great point where, you know, it's great to be a specialist and to know this kind of stuff, but the general law will not go away. The general skills and knowledge that you have will always be valuable. So I don't have any other questions myself. If anybody in the audience has any questions, feel free to ask them. Perhaps if there are no other questions, perhaps you could take us a little bit through the research you've done so far with Claire's in terms of the financing world, or I'm not sure, maybe they're not related, but I know we spoke before the call about D-Factor and how they're tokenizing invoicing or invoices, I should say, and I'd be very interested to hear about the practical applications of that.
Yeah, I mean, for sure. So I know that D-Factor already has, I don't think I have any slide that I can show, but D-Factor already has some companies that have been onboarded and that are indeed already getting alternative financing through the tokenization of their invoices. So I would say that it is working, what they have proposed to do. And also regarding Claros, they are constantly investigating about more use cases that can be added, and new subcourts that can be created. And one of them is a partnership with MakerDAO, which is, well, obviously, I think everyone knows, because MakerDAO are the creators of DAI, which is a stable coin that is backed by the US dollar. So one DAI is always equivalent, or should always be equivalent to $1. So that's why it's called a stable coin. And they're already doing this research a few I would say 2 years ago with MakerDAO, and it was specifically as using Claros. I can even show you something, I think. Well, maybe not. I was going to try and share my screen, but I'll have to stop this presentation and open a new window. They are using researching how Claros can be used for insurance, DeFi insurance platforms. So they have definitely been researching about Claros's use cases on the finance world. And I must say that there are other Claros fellows, it's not only me, and some of my colleagues in this fellowship are also researching about other use cases related to, for example, tokenization of real estate. So I decided to focus more on liquidity and financing purposes, because I'm really interested in that topic. But obviously, Claros can be also used, and is already being used, as an arbitrator for insurance claims. You have, for example, a platform called Unslashed, which is a DeFi insurance platform that already integrates Claros. And then, I mean, it has, I would say, almost infinite use cases. So it's definitely very, very interesting to keep accompanying their development, I would say.
And then I suppose coming back to the idea of decentralized finance, or decentralized justice rather, and the problem of lack of enforcement, especially when we're dealing with real world assets. I wonder, is that the biggest stumbling block? At least it seems to be so in my opinion, that when you're dealing with Claros as an example, or whatever other decentralized justice platform that you might use, it's fine then to get the decision for you on chain, but off chain in the real world, how
Yes.
do you say get access to the asset, or actually affect that real world asset that might be in a vault, that might be real estate? And where do you see this solution coming about? I mean, where are we going to see it cross that divide and start to be able to have an effective enforcement mechanism on, shall we say, traditional old world assets?
Yeah, so for sure, on the enforcement part, for example, in one of the blog articles that I mentioned, the one on Claros case in Mexico, I believe that Claros was used as a tool, or like as an add-on to reach a decision. So it was used by the courts to solve the more technical issues. But then obviously the main decision, I would say, that in this case related to tokenization would affect the real world asset in itself, and for example, ownership questions, that decision was taken by traditional courts. So I don't really see Claros as disrupting the whole traditional court system. And actually, my LLM thesis was precisely on this question: if the centralized justice would completely invalidate the traditional court system, obviously in many years. But I reached the conclusion that no, it would just create a new form of justice, which we now call decentralized justice. And it would indeed be an alternative to traditional justice in some very specific use cases, but I do see it as more as an add-on or as a more technical tool to be used by the people who make the decision. So in this case, the courts. But I mean, that's my view. So traditional courts will continue to exist. We will still need judges. We will still need lawyers. Lawyers will not be replaced by robots, like many people say. But that's a whole other discussion with ChatGPT and all of that.
Absolutely. Yes, and I think you're spot on when you say that, you know, real world court or traditional courts will stay and traditional lawyers will stay, but perhaps it's the piece about increasing their knowledge and crossing the divide into this new frontier of technology, and maybe even working in tandem with, you know, on-chain dispute resolution, decentralized justice, and being able to, you know, because they are two separate worlds in terms of the digital twin and the real assets. So perhaps we will need these kind of hybrid dispute resolution processes to, you know, resolve the dispute in both of those contexts. So I think
I also believe so.
It's a very interesting and fast moving field. Inês, if there's anything else you want to talk about, please feel free. We have 5 minutes left, and if the audience have any questions, please don't hesitate to write in the chat.
Yes, and if anyone wants to now turn on the mic and just speak freely, feel free to do so. Maybe I will just show you the Google Forms, since we don't seem to have any questions. I don't know if you are still seeing my screen or not.
Yes.
Okay, great. So this is a form. I see that I already have one more answer than I had. So thank you for for whoever answered. This questionnaire is open to anyone, so you don't need to know what tokenization is. Obviously, if you're in this presentation, you already know what it is. But I start by asking if people know any projects, if they have invested in them, if not, why. And I can say that most people so far have answered that they're still looking for projects. that's the most popular answer. Then I have the biggest challenges related to tokenization. What are some of the potential disputes? And here I had a lot of people writing their own answers. I explained a bit what are the centralized courts and what is Claros, and if Claros can solve some of these disputes. Here I just focused on the main use case, because I was still researching the other use cases, and I also didn't want this questionnaire to be too long. And then we have the challenges, if Claros can be used to for the verification of off-chain assets. And finally, if future regulation, let's say the DLT pilot regime that will come in force very soon, and it's related to tokenization of securities. And then an optional question asking in which field did people work, and I got some answers from people in the legal field, also in the tech field, but mostly people that were working in non-tech roles. So you don't need to be a programmer nor a lawyer to answer these questions.
Perfect. Inês, it was an absolute pleasure. Thank you for taking us through the wonderful world of tokenization. As I said at the outset, it was very detailed and very well delivered. Thank you very much again. And yes, we'll end the session here. And I want to thank also the audience for logging on late or early in the evening, depending on where they are in the world. And please keep an eye out on the ArbTech LinkedIn and on our website for future webinars. We have a webinar coming up actually on the 24th of February, which will be around space tech disputes with two esteemed speakers in the field. And I think that will be also a fascinating discussion. So please do join us there if you have the time. Thank you very much, everyone.